A very warm welcome to all. Today, I, Reeya Khanna, a legal intern under LEXIS and Company, am here virtually to explain my topic types of procedure in session trial and warrant trial. This particular video is the part 2 of the video. In the part 1 of the video, we understood what basically means a trial. And as I told you that trial is the word trial has not been defined anywhere in the criminal procedure code. However, it is a commonly understood stage of trial which begins after framing of charges and ends with either the conviction or the acquittal of the accused. Further, I gave you a very brief meaning of session and warrant trial, after which I explained sections of warrant of session trial in detail, in great detail, where we talked about three stages of trial: stage 1, stage 2, and stage 3 of sessions trial. Now, in this particular video, we shall be understanding the three stages in the cases of warrant trial. As I said earlier as well in the previous video, section 238 to section 250 deals with the trial of warrant cases by magistrate. So now, without further ado, let us understand what is the procedure in the warrant trial. So, Chapter 19 of CRPC starting with section 238 and ending with section 250 deals with the provisions governing the warrant trial, as explained earlier as well. So, for the trial of warrant cases by magistrate, the procedures are prescribed in the Act. The one adopted by the magistrate in cases instituted on police report are from section 238 to section 243 of CRPC and section 248 to section 250 of CRPC. And the other is for case instituted otherwise the police reports, starting from section 244 to 247 of CRPC and 248 to 250 and 275 of CRPC. Now, let us understand what is the first stage of trial under the warrant trial. With the compliance of section 207, the magistrate must satisfy himself that he has been supplied with all the necessary documents with the charge sheet if, after consideration of charge sheet filed under section 173, the magistrate considers the charge against the accused to be groundless, then the magistrate shall discharge the accused and record the reasons for such discharge as per section 239. But section 240 provides that if in case the magistrate is of opinion that the accused is triable and the charges are sufficient against him, then the charges shall be framed by the magistrate against the accused. Talking about case laws, in the case of State of UP versus Lakshmi Brahman, in the context of duty of magistrate, at the stage of commitment, the court considered the nature of duty lying upon the magistrate with regard to observance of section 207 CRPC, and it is said that the duty cast on the magistrate by section 207 has to be performed in a judicial manner. Moving on to the second stage of trial under the warrant trial, after framing of charges under section 240, the magistrate has to prove under section 242 of CRPC and up under subsection 3 of 242 CRPC to proceed to take all evidences as may be produced in support of the prosecution. This provision and other provisions are mandatory under section 243 of CRPC. The provisions of section 243 applies both cases instituted under police report and cases instituted under private complaint. As I had explained in the very beginning of procedure of warrant trial, I had explained a few sections from 238 to 243, which are the cases instituted on police reports, and from section 244 to 250 and 275 are the cases instituted by magistrate other than the police report. So cases otherwise by the police report are the private complaints only, right? Further, in the case of Vijay Raj versus State of Rajasthan, the procedure to be followed after the accused is called upon to enter his defense is same in both the cases instituted upon a police report and those instituted otherwise than on a police report. Further, in the case of P. Saravanan versus State, represented by the Inspector of Police, it is pertinent to note that the recording of plea of guilty, both in a warrant and in a session under a session case under Section 241 and Section 229 of CRPC, only the charges has to be read out to the accused, which is a very important part. The charges must be specific, unambiguous, very clear, and the admission by accused must be unambiguous and unqualified, unconditional. Right? Further, talking about private complaint, in cases of private complaint under warrant trials, there are only two stages of trial. So in the first stage of trial, if the case is instituted on a private complaint and accused is brought before the magistrate, then the prosecution must satisfy itself with all the evidence produced and issue a summon to any of the witness, directing him to attend or produce any document as per Section 244. Further, in the second stage of trial, as per Section 247, the defense counsel produces his evidence to support the accused. If at all, if the framed charges against the accused and the magistrate finds him not guilty, then the order of acquittal is released. But if further the uh, if it is not guilty, then the order of acquittal is released. Further, let's talk about a case law. In the case of Narpat Singh and others versus others, as a matter of fact, attributing uncharitable remarks and initiation of proceedings under Section 250 of CRPC against the petitioner are in gross violation of principles of natural justice. Therefore, the impugned action is per se vulnerable on this count also. It is also noteworthy that registration of case against the accused persons by the petitioner and thereafter carrying out an investigation was pursuant to an order of the court of under Section 156 Clause 3 of CRPC. Thank you so much. That is all for this particular video. Thank you.